Mr. Chief Justice, distinguished members of the Senate, our friends, lawyers, fellow lawyers, it's a great honor for me to stand before you today to present a constitutional argument against the impeachment and removal not only of this president, but of all and any future presidents who may be charged with the unconstitutional grounds of abuse of power and obstruction of Congress. I stand before you today as I stood in 1973 and 1974 for the protection of the constitutional and procedural rights of Richard Nixon, who I personally abhorred, and whose impeachment I personally favored. And as I stood for the rights of Bill Clinton, who I admired, and whose impeachment I strongly opposed. I stand against the application and misapplication of the constitutional criteria in every case and against any president without regard to whether I support his or her parties or policies. I would be making the very same constitutional argument had Hillary Clinton, for whom I voted, been elected and had a Republican House voted to impeach her on these unconstitutional grounds. I am here today because I love my country and our Constitution. Everyone in this room shares that love. I will argue that our Constitution and its terms, high crimes and misdemeanors, do not encompass the two articles charging abuse of power and obstruction of Congress. In offering these arguments, I stand in the footsteps and in the spirit of Justice Benjamin Curtis, who was of counsel to impeach President Andrew Johnson, and who explained to the Senate that, quote, a greater principle was at stake than the fate of any particular president. And of William Evarts, a former Secretary of State, another one of Andrew Johnson's lawyers, who reportedly said that he had come to the defense table not as a partisan, not as a sympathizer, but to defend the Constitution. The Constitution, of course, provides that the Senate has the sole role and power to try all impeachments. In exercising that power, the Senate must consider three issues in this case. The first is whether the evidence presented by the House managers establishes, by the appropriate standard of proof beyond a reasonable doubt, that the factual allegations occurred. The second is whether, if these factual allegations occurred, did they rise to the level of abuse of power and/or obstruction of Congress. Finally, the Senate must determine whether abuse of power and obstruction of Congress are constitutionally authorized criteria for impeachment. The first issue is largely factual, and I leave that to others. The second is a combination of traditional and constitutional law, and I will touch on those. The third is a matter of pure constitutional law. Do charges of abuse and obstruction rise to the level of impeachable offenses under the Constitution? I will begin, as all constitutional analysis begins, with the text of the Constitution governing impeachment. I will then examine why the framers selected the words they did as the sole criteria authorizing impeachment. In making my presentation, I will transport you back to a hot summer in Philadelphia and a cold winter in Washington. I will introduce you to patriots and ideas that helped shape our great nation. To prepare for this journey, I have immersed myself in a lot of dusty old volumes from the 18th and 19th century. I ask your indulgence as I quote from the wisdom of our founders. This return to the days of yesteryear is necessary because the issue today is not what the criteria of impeachment should be, not what a legislative body or a constitutional body might today decide are the proper criteria for impeachment of a president, but what the framers of our Constitution actually chose and what they expressly and implicitly rejected. I will ask whether the framers would have accepted such vague and open-ended terms as abuse of power and obstruction of Congress as governing criteria. I will show by a close review of the history that they did not and would not accept such criteria for fear that these criteria would turn our new republic into a British-style parliamentary democracy in which the chief executive's tenure would be, in the words of James Madison, the father of our Constitution, at the pleasure of the legislature. The conclusion I will offer for your consideration is similar, though not identical, to that advocated by highly respected Justice Benjamin Curtis, who, as you know, dissented from the Supreme Court's notorious decision in Dred Scott, and who, after resigning in protest from the High Court, served as counsel to President Andrew Johnson in the Senate impeachment trial. He argued, and I quote, "There can be no crime, there can be no misdemeanor without a law, written or unwritten, express or implied." In so arguing, he was echoing the conclusion reached by Dean Theodore Dwight of the Columbia Law School, who wrote in 1867, just before the impeachment, "Unless a crime is specifically named in the Constitution, treason and bribery, impeachments like indictments can only be instituted for crimes committed against the statutory law of the United States." As Judge Starr said earlier today, he described that as the weight of authority being on the side of that proposition at a time much closer to the framing than we are today. The main thrust of my argument, however, and the one most relevant to these proceedings, is that even if that position is not accepted, even if criminal conduct were not required, the framers of our Constitution implicitly rejected, and if it had been presented to them, would have explicitly rejected, such vague terms as abuse of power and obstruction of Congress as among the enumerated and defined criteria for impeaching a president. You will recall that among the articles of impeachment against President Johnson were accusations of non-criminal but outrageous misbehavior, including ones akin to the abuse of power and obstruction of Congress. For example, Article 10 charged Johnson did attempt to bring into disgrace, ridicule, hatred, and contempt and reproach the Congress of the United States. Article 11 charged Johnson with denying that Congress was authorized by the Constitution to exercise legislative power, and denying that the legislation of said Congress was obligatory upon him. Pretty serious charges. Here's how Justice Curtis responded to these non-criminal charges. Quote, "My first position is that when Congress speaks of treason, bribery, and other crimes and misdemeanors, it refers to and includes only high criminal offenses against the United States, made so by some law of the United States, existing when the acts complained of were done. And I say," he continued, "that this is plainly to be inferred from each and every one of the provisions of the Constitution on the subject of impeachment." And I will briefly review those other provisions of the Constitution with you. Judge Curtis's interpretation is supported. Indeed, in his view, it was compelled by the constitutional text. Treason, bribery, and other crimes and misdemeanors are high crimes. Other high crimes and misdemeanors must be akin to treason and bribery. Curtis cited the Latin phrase nocitur ai soci, I'm sorry for the mispronunciation, referring to a classic rule of interpretation that when the meaning of a word that is part of a group of words is uncertain, you should look to the other words in that group that provide interpretive context. The late Justice Antonin Scalia gave the following current example. If one speaks of Mickey Mantle, Rocky Marciano, Michael Jordan, and other great competitors, the last noun does not reasonably refer to Sam Walton, who was a great competitor, but in business, or to Napoleon, a great competitor on the battlefield. Applying that rule to the groups of words treason, bribery, and other high crimes and misdemeanors, the last 5 words should be interpreted to include only serious criminal behavior akin to treason and bribery. Justice Curtis then reviewed the other provisions of the Constitution that relate to impeachment. First, he started with the provision that says, "The President of the United States shall have the power to grant reprieves and pardons," listen now, "for offenses against the United States, except in cases of impeachment." He cogently argued that if impeachment were not an offense against the United States, was not based on an offense against the United States, there would have been no need for any constitutional exception. He then went on to a second provision. "The trial of all crimes, except in cases of impeachment, shall be by jury. This demonstrated, according to Curtis, that impeachment requires a crime. But unlike other crimes, it does not require a jury trial. You are the judge and the jury.